Good afternoon, Mr. Chair and members.
Please.
Thank you. I'm here today to present to you SB 316, a bill that will expand the availability of placements while also reducing delays in relative placements for children in foster care. 316 will address impediments to appropriate relative and foster care placements by conforming state law to federal requirements regarding caregiver criminal history reviews. Unfortunately, California has a complex and ineffective exemption process, and our goal with this bill is to align the list of non-exemptable crimes with those required by federal law. Current state law does two things with regard to the criminal history of a prospective foster or kinship caregiver, and which are overly broad and too restrictive. Number one, California has several lists of crimes that have been deemed non-exemptable. Secondly, for all other crimes in which any household member has been convicted, no matter how minor, how long ago, or how unrelated to child safety, an exemption must be granted to approve the home for placement. The changes this bill proposes in no way compromises child safety. California law will continue to prohibit, without any discretion for exemptions, placement with any person with a serious or violent felony conviction or with assault or battery, drug-related felony conviction within the past 5 years. It's important to consider this proposal in the context of the major culture shift brought about by AB 403 and the new continuum of care reform effort that is really refocusing our foster care system as we know it. As you all know, AB 403 requires a statewide implementation of the resource family approval process, and under the RFA, all foster and relative homes will be required to undergo a psychosocial assessment, which will involve several face-to-face interviews and a thorough consideration of any criminal history of the caregiver or household members. Also, as a result of the continuum of care reform effort, we will be really kind of eliminating group homes as we've come to know them here in California. And what that means across the state, but particularly for my home county of Los Angeles, is we have to get very busy very quickly finding, recruiting, and licensing foster care homes to make sure that we can accommodate the nearly 6,000 children that are currently in group homes. As the analysis states, I've offered technical clarifying amendments to fix legislative council drafting errors, and I've committed to take an amendment in the next policy committee. We were double referred. We go to Human Services next. That requires a judge to sign off on placement with a relative or non-relative extended family member that is pending a criminal records exemption if all parties agree that the placement is in the best interest of the child. With me today to speak in support of SB 360 is Martha Matthews from Public Counsel and Yolanda Pinata from the Children's Law Center.
Thank you.
I ask for your aye vote.
Thank you. Your first witness, please.
Thank you, Chairman Stone and members. We thank Senator Mitchell for this legislation. The basic purpose of this legislation is to make sure that children who cannot remain safely at home are moved as quickly as possible into foster homes, preferably with relatives and other people who are familiar to them, and that the supply of foster homes is sufficient so that children do not have to move long distances from their homes, schools, and neighborhoods, and so that siblings are not separated. And to accomplish those goals, the legislature has already prioritized placement with a relative or someone known to the child whenever possible. The problem is that the relative themselves and everyone in their household has to have a criminal background clearance, as does everyone who comes from the general public to apply to be a foster parent. And as Senator Mitchell explained, current law on those criminal background clearances is frankly a mess because new federal requirements were added on top of old state law in 2008. And so what our bill would do first is simplify the law regarding what are called non-exemptable crimes, crimes that preclude you from ever being a foster parent, no matter how long ago they were committed. And there is a federal list of non-exemptable crimes. Our bill would just say, that's also the state list of non-exemptable crimes. And the effect of that is it would eliminate old state law that had almost, but not quite, the same list of non-exemptable crimes. And it was really confusing for social workers to work through. the net result is that a very few crimes would move from the non-exemptable category to the needs an exemption category. And those are a few, they're either nonviolent felonies or misdemeanors that were part of those really long state lists of crimes that were in the old law. One example is indecent exposure. It can be a misdemeanor. It can be something as non-serious as a frat boy prank, and it's non-exemptable because it's a sex registry offense. So under our bill, because that's not violent, not involving sexual abuse of a child or rape or sexual assault or any of those really serious felonies, it would move into the category where it's considered on a case-by-case basis. But most of the non-exemptable crimes would say exactly where they are, non-exemptable. Then what the bill does is it creates a second tier of crimes that require an exemption no matter how long ago they were committed. And those are crimes, whereas they may not be violent felonies, they're crimes that you worry about. And those are any crime that has anything to do with any form of sexual misconduct, any form of abuse or maltreatment of a child, and any violent crime. Those are in that category of doesn't matter how long ago they were committed, you still need to go through the exemption process. For crimes that aren't like that, that is not violent, not sexual, and not related to a child victim, you need an exemption if it was a felony within the past 7 years or a misdemeanor within the past 5 years. And then the bottom tier is all of those crimes that are many, many years ago, not violent, not related to a child, and not involving sexual misconduct. Those crimes, instead of a formal exemption process, would be considered as part of that psychosocial assessment that Senator Mitchell explained every prospective foster parent has to go through. So I know it's kind of wonky, but what it does is it takes that workload burden and that paperwork burden and it puts it where it's really necessary for crimes that have some possible bearing on the safety of a child. And it relieves the workload burden for, say, petty theft 30 years ago. A crime that everyone agrees has no bearing on child safety, but they have to go through the exemption process anyway. And what often happens is, because a crime was 30 years ago, no one can find the records. And so a grandmother or an aunt, say, whose husband committed a minor crime many, many years ago in another state, could end up being denied approval simply because no one can find the records. And that obviously doesn't contribute to child safety at all. So it's a very technical bill, but we believe that its net effect will be to reduce the workload burden on county child welfare agencies and the state, and ultimately to contribute to the safety and well-being of children. Thank you.
Thank you. Additional witnesses in support.
Good morning, honorable members, and thank you, Senator Mitchell, for authoring this legislation. My name is Yolanda Pineda, and I'm with the Children's Law Center of California. We represent children in foster care in Sacramento, Los Angeles, and Placer counties. One common scenario our clients often face are being placed in the home of a stranger or in congregate care because a relative or family friend who is available for placement has a petty conviction from over 20 years ago, or a similarly non-child safety related conviction. Many times the social worker, the judge, the parents, the child are all in agreement that this caregiver would provide a safe and stable home for the child. But the child can't be placed there, not until a formal exemption is issued, as one is currently required for every conviction, no matter how old or unrelated to child safety it may be. SB 316 would allow the child to be placed immediately at the beginning of a case if, after review of the prospective caregiver's criminal history, all parties and the court agree that the placement is in the child's best interests. Another example where a potential caregiver is excluded from being considered for placement due to a conviction that the county agency mistakenly believes is non-exemptable because the current law is extremely confusing. A third scenario we repeatedly encounter is undue delays in placement because of the burdensome exemption process. We recently had a case where a teenager languished in a group home for more than a year after his grandparents came forward asking to be assessed for placement. This is expensive, and it's also traumatic for the child. The grandparents had a large binder with documents that they sent relating to the very old conviction. They also had a very long call log of all of the people who they contacted when they were challenging the decision that the very old conviction did not qualify for an exemption. These grandparents were appropriate and caring. They ultimately succeeded, and they are now the legal guardians of this young man who continues to make progress in their care and supervision. As a final comment, it's important to emphasize that SB 316 will not compromise child safety. Rather, the bill presents a sensible approach to the assessment of prospective caregivers' ability to safely provide a home for a foster child in light of his or her previous criminal history, and benefits children by reducing delays and needless denials of placement approval for relatives who can provide safe and loving homes.
If you could wrap up, we'd appreciate it. Thank you.
We urge you to support this bill.
All right. Additional witnesses in support. All right. Bill's been moved and seconded. Additional witnesses in support.
William Smith.
Push the button there. Or, thank you.
William Smith with the Alliance for Children's Rights in support.
Rebecca Gonzalez, National Association of Social Workers, California chapter in support.
Hello, I'm Louis Gasper, a Policy Committee Representative for California Youth Connection and current foster youth in support.
Thank you. Additional witnesses in support. Seeing none, witnesses in opposition. That'll teach him. All right. Seeing none, comes back to the committee. Questions or comments? All right. Seeing none, you may close.
Thank you very much. I'd like to thank the consultant for a really comprehensive analysis that identifies how California fell short in not more appropriately aligning our policies with federal law. And I just think it's also important that I wanted to clarify why I made the correlation to the change in policy around foster care, because it really is a fiscal issue, that we're not creating a new additional bureaucratic layer of review. It really is a streamlining process, and we're very clear that with the new resource family approval process, it's a more comprehensive, appropriate process for reviewing family caregivers or foster family placement, because it includes a psychosocial assessment, in-person interviews, as well as a thorough consideration of any criminal history. And we feel this policy fits perfectly in sync with the new direction in the foster care system. And with that, I ask for your aye vote.
All right. Thank you. The motion is due pass to Human Services, where the author will take the amendments.
Mm-hmm.
Due pass. Oh, I'm
So there
sorry.
are some technical amendments that are being taken here. So I
Right.
guess the recommendation would be due pass as amended. And I've made the commitment
Got
to
it.
take additional amendments in Human Services with
right.
regard to the judicial review.
Due pass as amended with further amendments to come in Human Services. Thank you, Senator.
Yes, sir.
Call the roll.
Stone, Wagner,
Aye.
Wagner, I, Alejo, Alejo, I, Chow, Chu, Gallagher, Garcia, Garcia, I, Holden, Mainshine, Mainshine, I, Ting.
Two more votes on the call.
The bill is on call. Thank you, Senator.
Thank you very much. Removing my cup from the desk.
All right. We are looking for Senators Hueso or Leno. Wonderful. Senator, you are up next with SB 899, which is item 2. Ready? I didn't see. Proceed at your leisure.
Thank you. We're waiting for Assemblymember Gonzalez. He's going to co-present, and I'm actually if you will give me 2 minutes. Is
Sure.
that possible? Because we don't have another.
We're waiting for Assemblymember Gonzalez.
Oh, good, good. Give me 1 second.
Certainly. Certainly. Wait. This one. This is Lauren. This out of here. That one.
Okay, we're all set. Sorry about that.
No, proceed at your leisure.
Thank you. I'm very proud today to present SB 899. It's an update on the Gender Tax Repeal Act that extends the prohibition against gender price discrimination for services. This bill will also include goods. I want to start by accepting the committee amendments on page 8 of the analysis. Thank you to the staff for that, working with our office. Many of you have heard of the example of a pink and blue razor and their cost differences. And we have one here that we have permission to use a prop here.
Of course.
To make a point that when you look at these two items, you see virtually no difference other than the color. I presented these two razors in the Senate Judiciary Committee as well. Clearly, you can see that these razors are identical in every way besides the fact that one is pink, one is blue. The pink razor that was purchased costs $5 more for a 12-pack than the blue razor, $5 more. But what makes this gender discrimination? If your focus is on the color, then you're focusing on the wrong thing. The fact of the matter is, the pink razor is marketed toward women and located in the women's aisle by the retail. The blue razor is marketed toward men and located on the men's aisle. If it were not for that difference, these razors would simply be pink and blue. But what is wrong with that? What is going on? Retailers and manufacturers are labeling nearly identical products to one another and on average are selling the one they marketed toward women at a premium. That is evidenced by the New York City Department of Consumer Affairs report of 2015, From Cradle to Cane, Cost of Being a Female Consumer. One example of it, one example on its own looks like a ripoff. But the New York report highlighted 800 different products in 35 different product categories. Women's products cost more in 30 of the 35 categories. Women's products cost more 42% of the time. And on average, women's products cost 7% more. While anyone could compare the men and women's version of a product and buy the cheaper one, that is simply not how most people shop. People do not think to go to the men's and women's aisles and compare prices. It's often very inconvenient for consumers to go from one retailer to the next. In communities like mine, it's virtually impossible for poor people, for people that don't have transportation, that people who don't own a car can afford a car. My mother had to walk often several blocks with her children to go to the only store in the neighborhood and often did not have a choice on what she purchased or how much it cost. Not being able to drive, not being able to afford a car, we were left to walk door to door. The problem is not, as the committee analysis stated, a Goldilocks fairy tale, where retailers will be forced to label a soft bed for women and a hard bed for men, and one that is just right for babies. That is not the issue we're talking about. This is where we completely miss the point of what this bill is about. The problem is that retailers are taking two identical beds that have a different color, putting them in two different parts of the store, and they're labeled for men and women, and charging more for one in the women's department or in a completely different part of town. This bill simply updates the Gender Tax Repeal Act to prohibit gender price discrimination for substantially similar goods. The goods must share the same brand, the same functional components, and share 90% of the same materials or ingredients. Everything we've done in this bill has been to focus, and this testimony that we're hearing today goes into the the record and the testimony and the intent of the bill. When we look at the intent, we're not looking to create any kind of gray areas. We want the bill to be very clear that when it's the same product, but one is marketed to women, one is marketed to men, and they cost different, that's illegal. I know the opposition is focusing on the gray areas. It would hard to bring a lawsuit that falls clearly in the gray areas on this issue. That's why we feel that we have worked with the opposition. We have worked very hard to clarify the language. We have worked very, very hard to identify the issue, to define it, and to put it into statute in a way that can be enforced, in a way that can be fair for everybody involved. What we don't want is an environment in our state that allows discrimination to happen in an environment where discrimination is very common. Retailers under this bill are allowed to pass through prices to consumers if the prices are set by the manufacturers or distributors and out of their control. That was, again, an amendment that we worked on to make this bill fair. Amazon would be protected from the male and female price difference in the razors that the committee analysis points out, because in that case, two different sellers were providing the products on Amazon, and the price differences were out of Amazon's control. Again, for those instances, we provide ample clarifying language in the bill to address the problem, to define the problem, and to ensure and try to reduce frivolous litigation, as has been argued by the opponents. The opponents are arguing that this bill would lead to frivolous lawsuits. In the 20 years of the existence of the Gender Tax Repeal Act, there have been few lawsuits brought. There have been lawsuits where there has been discrimination, and you can't point to an overabundance of frivolous lawsuits. Other people have tried to liken this bill to the disability laws that have created challenges out there in the community where lawsuits have been brought up on businesses. The issue with that comparison, though, is that lawsuits weren't brought upon these businesses for complying with the law. These were businesses out of compliance. And it's hard to argue that those are frivolous lawsuits. Again, I have worked with this legislature to try to make that a fair process, and we have. We voted some clarifying conditions in the state of California to reduce frivolous lawsuits. I'm opposed to frivolous lawsuits. I've been a victim of frivolous lawsuits. I'm currently fighting a frivolous lawsuit right now. If anybody hates frivolous lawsuits, it's me. But what has that law related to disabled accessibility accomplished? It's actually accomplished providing greater access to the disabled community to important facilities, business facilities, government facilities. It's easier for them to walk through the streets now. It's very important legislation if you're disabled. I had an opportunity to be disabled for a 6-month period, and I became very sympathetic of what it's like not to be able to get around the community and to have a difficulty getting access. It's monumental when you see what has been accomplished in this country because of that law. And we have lots to celebrate. Yes, there have been lawsuits filed, but corrective action has been taken, and it's made for a better world for the people of our country. I believe this law will have that effect. I believe that people will be challenged where they need to be challenged, where discrimination exists. I want to kind of call out another issue on the report. I'm sorry to do that. But as I read the report, I was very disappointed by an entry that was made saying that Consumers have an option to buy a scooter that's blue over one that's pink, and in that practice save $25 and still go to their daughter and say, teach them an important lesson about discrimination. That provides an opportunity that because we have this existence of discrimination in our state, that we can talk to our kids about why discrimination is bad. Having lived through discrimination, living through discrimination now, I can tell you I don't want to ever have that conversation with my children. Have to explain why they live in a world where we accept discrimination. We have to have a conversation about it with our kids. I don't want people in our state to have to sit down with their daughters or their sons and ever talk about why gender discrimination exists. Why should we do that? Why should we have to live in a world where we don't do anything about it, but we encourage people to talk to their kids about discrimination and why it's a bad thing? We need to protect people from discrimination. We need to level the playing field. The job of government is to provide a safety net for the people that cannot defend themselves. All consumers are not equal. Yes, we need to teach people to be consumers, but sometimes it takes decades to educate a good consumer. In the meantime, in California, we're saying you're a bad consumer, it's okay to get ripped off. It's okay. You live in a poor part of town, you have very limited choices, it's okay for you to be ripped off. We can change that today. And yes, lawsuits may be filed. Lawsuits may be filed by this bill. And that's not something that I'm seeking. I'm seeking for a practice to end. But lawsuits may have to be filed to go after the bad actors. And in doing so, I think we'll start to chip away. This bill will by no means end discrimination, but it will be a first important step. It's part of a campaign to build awareness, to change practices, to break down stereotypes, to break down this cultural history that we have in our country that makes it so that there is an unequal playing field for people, whether it's based on religion or gender or ethnicity or any other matter. I think this is a very important bill. This will save people that are discriminated, both men and women, millions and millions of dollars. Usually it's the people that can't afford to spend extra for those products that are the ones that are going to save here. The people that need a safety net in the market. I also want to call something out in the report that I disagree with. In the report, the author of the report makes reference to free market capitalism, that the cultural and ideological factors may well be a product of patriarchy, and he acknowledges that, but price discrimination is a product of free market capitalism. Now, the importance of our role here is to provide a regulatory function of free market capitalism, to guide the market where we think it needs to go, where we are influencing energy markets by choosing clean energy. That is not free market capitalism. We are providing consumer protections out there in the marketplace. That's not free market capitalism. This bill, because under free market capitalism, the market will go where the market wants to take it. And we have an obligation to infuse our values into the market, to provide important protections for consumers, and to get a free market that builds a middle class, that ends discrimination, that ends racial profiling, that creates opportunity for all. That's not normally what a free market does. But that's what we can do as a legislature. Influence the market to move in the direction that's good for our society, good for our children, good for our families. Create a vibrant economy, not one that is decided by free market, one that eventually leads to monopoly. We need to prevent monopolies. We need to prevent discrimination. All those things are very important. This bill seeks to do that at some degree. Again, it's not, this bill will not end discrimination. It will not fix every problem, but it will fix a lot of problems in the marketplace, and I urge your support today. We have some important speakers today